নাই, যে কারণে জাস্টিস ডিলেড এবং জাস্টিস ডিনাইড, অর্থাৎ দীর্ঘ সূত্রিতার কারণে বিচার আমরা দিতে ব্যর্থ হচ্ছি। এই অবস্থায় আমাদের নিজেদের যে কিছু ব্যর্থতা আছে সেই জায়গাটাও আমাদেরকে মূল্যায়ন করতে হবে, আমাদেরকে আত্মজিজ্ঞাসা করতে হবে যে কি করে আমরা আবার সেই আস্থার জায়গায় ফিরে আসতে পারি। একটা সময় ছিল আমরা যখন দেখতাম যে দেশে বা সমাজে কোনো একটা ঘটনা ঘটলেই বলা হতো যে বিচার বিভাগীয় তদন্ত চাই। দুঃখের বিষয় সেই কথাগুলো এখন আর আমরা শুনতে পাই না। এই একটা বিষয় আমাদের প্রমাণ করে যে আমরাও আস্থার সংকটে আছি। এই আস্থার সংকট দীর্ঘদিন ধরেই চলছে, কিন্তু গত 15 বছরে এটা মহিরুহ লাভ করেছে, অর্থাৎ মানুষ আমাদের উপর থেকে সম্পূর্ণরূপে আস্থা হারিয়ে ফেলেছে। আমি দ্বিধাহীন চিত্তে বলতে চাই যে এর পিছনে আমাদের তৎকালীন সুপ্রিম কোর্টেরও একটা বড় দায় আছে। তারা যে যোগ্য নেতৃত্ব দেওয়া দরকার ছিল সেই নেতৃত্ব তারা সঠিকভাবে দিতে পারে নাই। এখন সময় এসেছে আমাদেরকে এই জায়গাগুলো ভেবে দেখার, আমরা কি করে আমাদের আস্থার জায়গায় ফিরিয়ে আনতে পারি। একই সাথে বিচার প্রক্রিয়ায় জড়িত সকল পক্ষকে যাতে আমরা একই সাথে সমন্বয় করতে পারি, যেন আমাদের তদন্ত প্রতিবেদন ভুল না হয়, আমাদের সিভিল বিচার ব্যবস্থার কার্যক্রম যেন ভুল না হয়, এই জায়গাগুলো আমাদেরকে দেখতে হবে। আমি আশা করি স্যার আজকে আমাদেরকে এই বিষয়ে একটা গাইডলাইন দিবেন, এবং এই গাইডলাইন সহ ভবিষ্যতে আমরা কিভাবে এই আস্থার জায়গাটা ফিরে আসতে পারি, ফিরে আনতে পারি, সেই চেষ্টা করব। আমাদের বিচার বিভাগে যারা কর্মরত আছি আমাদের তাদের প্রতি অনুরোধ, একই সাথে আমরা যেন আমাদের আত্মজিজ্ঞাসা করি যে আমাদের কোথায় ঘাটতি আছে বা বিচার ব্যবস্থায় কোথায় ঘাটতি আছে, সেই জায়গাগুলো আমরা যেন অতিক্রম করতে পারি। আজকের এই অনুষ্ঠান আয়োজনের জন্য আয়োজক কর্তৃপক্ষকে ধন্যবাদ জানাচ্ছি। আজকের কিনোট উপস্থাপক হিসাবে মাননীয় বিচারপতি মইনুল ইসলাম চৌধুরী স্যারের প্রতি কৃতজ্ঞতা জানাচ্ছি। আমার বক্তব্য শেষ করছি। আসসালামু আলাইকুম।
ধন্যবাদ স্যারকে। আজকে আপনারা ইতিমধ্যেই অবগত হয়েছেন যে বাংলাদেশের প্রায় সারা দেশ থেকে আমাদের মাননীয় জেলা জজ স্যার বৃন্দ, মাননীয় মহানগর দায়রা জজ স্যার বৃন্দ, মাননীয় চিফ জুডিশিয়াল ম্যাজিস্ট্রেট, চিফ মেট্রোপলিটন ম্যাজিস্ট্রেট সহ সকল পর্যায়ে অলরেডি 165 জন বিচারক আমাদের এই ওয়েবিনারে যোগদান করেছেন। আশা করছি আরো অনেকে যোগদান করছেন। ইন দ্য মিন টাইম হয়তো আরো বেশ কিছু যোগদান করবেন। তো আমরা সবাইকে শুভেচ্ছা জানাচ্ছি, স্বাগত জানাচ্ছি। আজকে আমরা যেহেতু অলরেডি আমাদের প্রায় আধা ঘন্টা চলে গেছে, আমরা আর কোনো সময় নষ্ট না করে সরাসরি আমাদের আজকের যিনি প্রধান আকর্ষণ, আমাদের শ্রদ্ধেয় সর্বজন শ্রদ্ধেয় অভিভাবক এবং যিনি সত্যিকার অর্থে বিচার বিভাগের, তিনি নিজেই একজন প্রতিষ্ঠান, তাকে আলাদা করে পরিচয় করে দেবার মতো তেমন কিছু নাই। স্যার যে ল্যান্ডমার্ক জাজমেন্টগুলো দিয়েছেন বিচার বিভাগের স্বার্থ সংশ্লিষ্ট সহ জাতীয় স্বার্থে, যেমন মোবাইল কোর্টের রায়কে অবৈধ ঘোষণা, অবৈধ এবং অসাংবিধানিক ঘোষণা, ওয়ারেন্ট অফ প্রিসিডেন্স মামলা, ষোড়শ সংশোধনী সহ বেশ কিছু ল্যান্ডমার্ক জাজমেন্ট স্যার দিয়েছেন। স্যারের জাজমেন্ট থেকেই মূলত স্যারকে আমরা চিনতে পেরেছি। তো আমরা অত ভূমিকায় যাচ্ছি না, আমি সরাসরি এখন আমাদের মাননীয় স্যারের কাছে চলে যাচ্ছি। আমি এ পর্যায়ে অনুরোধ করছি আজকের এই ওয়েবিনারের কিনোট উপস্থাপন করার জন্য আমাদের মাননীয় বিচারপতি জনাব মইনুল ইসলাম চৌধুরী স্যারকে। স্যার।
Yes, thank you very much, Mr. Said Shubho. The caption of my write-up is Trust Deficit in Bangladesh Judiciary, a Pathological Diagnosis. As you know, the Constitution is the suprema lex, I mean supreme law of the land. As per the Constitution, there are three organs of the state, namely the executive, the legislature, and the judiciary. The most striking feature of the judiciary is its power of judicial review. This power of judicial review is exercised by the High Court Division under Article 102 of the Constitution. Now a pertinent question arises: does this power of judicial review make the judiciary superior to other two organs of the state? The answer is obviously in the negative. As a matter of fact, the judiciary is coordinate and co-equal with other two organs of the state. However, the Supreme Court is the guardian of the Constitution. As the guardian of the Constitution, it is the duty of the Supreme Court to check the excesses of the executive and the legislature in appropriate cases. In other words, the Supreme Court brings the executive and the legislature to the constitutional path for their aberrations as and when required. But as a matter of course, a relevant question crops up. Who will check the excesses of the judiciary? There is no other organ or entity to check the excesses of the judiciary within the four corners of the Constitution. What I am driving at boils down to this. The judiciary should check their own excesses according to the nature and exigency of any given situation. It goes without saying that the horizon of the writ jurisdiction of the High Court Division is being expanded through judicial activism with the passage of time. But this judicial activism does neither mean judicial adventurism nor judicial populism. In this regard, the Supreme Court should take care to see that it doesn't lapse into judicial overreach. This is because judicial overreach is violative of the doctrine of separation of powers between the three organs of the state. What is of paramount importance is that the executive, the legislature, and the judiciary should function effectively within the parameters set by the Constitution itself. Though sometimes some overlappings seem plausible and inevitable. Law is by nature a mixed concept. It is often varied and complex philosophies, yet it is one of the deepest concerns of the civilized humanity because it offers protection against an anarchy. But in spite of coexistence of diverse legal philosophies, the concept of law is more easily understood than defined. According to Edmund Burke, law and arbitrary power are in eternal conflict. In other words, there cannot be any coexistence of law and arbitrary power. Precisely speaking, law and arbitrary power are mutually exclusive. A new concept titled constitutional morality has evolved over the years by the superior courts of the subcontinent. Now a very vital question arises. What is meant by constitutional morality? By the term constitutional morality, we mean adherence to the core principles of the Constitution. The Indian Supreme Court for the first time applied and expanded the principles of constitutional morality in a landmark judgment in the case of Suresh Kumar Kaushal and others versus Naz Foundation and others. Coming back to our jurisdiction, the constitutional morality is yet to take firm roots. Hopefully, the Supreme Court of Bangladesh will come up with some trailblazing decisions on the principles of constitutional morality in the future. It is often said that the judiciary is the weakest of the three organs of the state. It is neither the power of the sword like the executive, nor the power of the purse like the legislature. Yet, it enjoys the highest respect of the people. But the respect of the people for the judiciary has been on the wane for a variety of reasons. You are all aware of those reasons, so I did not dilate upon them. Anyway, it is a truism that the judiciary is the guardian of justice, the shield of the vulnerable, and the compass of democracy. The judiciary indeed thrives upon public trust. This public trust in the institution is not merely desirable, it is the bedrock of a functional society. Without it, without public trust, the rule of law in the judiciary, the rule of law crumbles and chaos and pandemonium become the order of the day. Given the scenario, it is necessary to explore how the judges can fortify this public trust through their actions, decisions, and ethos. Let us begin with a fundamental truth that a trusted judiciary is the soul of democracy. It ensures that no individual, corporation, or the government is above the law. This is the essence of the rule of law. It protects the rights of the citizens, fosters economic stability, and deters injustice. In Bangladesh, where the echoes of our hard-fought independence and the July uprising of 2024 still resonate, the judiciary's integrity is tied to our national identity. Yet confidence cannot be demanded, it must be earned. This is very important. I repeat for the sake of emphasis. Yet confidence cannot be demanded, it must be earned. When the people doubt the impartiality and efficiency of the judicature, they turn to vigilantism. It is the solemn duty of the judges of all tiers to prevent this vigilantism by embodying the principles they are mandated to uphold. Judicial independence and accountability are twin pillars underpinning the rule of law and democratic governance. An independent judiciary safeguards human rights, ensures the separation of powers, and fosters an environment conducive to economic and social development. By, by the same token, accountability is essential to maintaining public trust and preventing misuse of judicial authority. Striking a fine balance between independence and accountability is crucial to preserving judicial integrity. Judges must be shielded from undue influence while remaining answerable for gross misconduct or dereliction of duty. As Justice Sandra Day O'Connor observed in her treatise titled The Threat to Judicial Independence, I'm going to quote her verbatim. A judiciary without accountability is likely to lose public. I repeat, a judiciary without accountability is likely to lose trust. A judiciary without independence is no judiciary at all. Similarly, Alexander Hamilton warned in the Federalist number 71 that the judiciary has neither force nor will, but has judgments, making its legitimacy wholly dependent on public trust. Judicial independence refers to the judiciary's ability to make decisions impartially, free from external pressure or interference. It encompasses institutional autonomy, decisional freedom, security of tenure and remuneration. Judicial accountability, conversely, demands that judges uphold the Constitution, apply the law fairly, and remain answerable for misconduct or mental and physical incapacity. An exclusive accountability mechanism ensures transparency and integrity without undermining judicial independence. The judiciary must remain a vigilant guardian of the rule of law, exercising judicial review as a potent weapon to protect the citizens from constitutional violations, aberrations, or abuses of power by the state machinery. Indisputably, judicial independence is the lifeblood of constitutionalism in a democratic polity. But this independence, as we understand, is for the judged and not for the judges. When it comes to judicial independence, the perception of the people is very important. Candidly speaking, the perception of the people about the judiciary as a whole is shockingly low. It is, without any shadow of doubt, an ominous sign and does not bode well for the nation. Judges are accountable to the Constitution, to the laws of the land, and above all, to their own conscience. Judges of the lower courts are accountable to the higher courts for their judicial performances. A judge is a trustee of sovereign judicial power of the Republic. Likewise, a minister is a trustee of sovereign executive power, and a member of parliament is a trustee of sovereign legislative power of the Republic. So there is parity between a judge at whatever level he may be, a minister and a member of parliament. All of them hold their respective positions in fiduciary character. By the way, the Commonwealth Latimer House Principles on the three branches of government and the 1988 Latimer House Guidelines for the Commonwealth Parliamentary Supremacy and Judicial Independence may be adverted to. Judgment writing is a creative art. So a judge is a creative artist. His works of art are his judgments. He is also a judicial craftsman. Judicial competence is the core of this craftsmanship. Through adjudication of disputes, he protects, upholds, and promotes human rights. In this sense, he is a human rights defender too. Judicial independence does not mean judicial high-handedness at all. There is no conflict between judicial independence and judicial accountability. Rather, judicial accountability reinforces proper exercise of judicial independence. So, judicial independence and accountability are not opposing ideals, but complementary pillars of constitutional democracy. Bangladesh's experience demonstrates that neglecting either principle undermines constitutional integrity and public trust. The recently promulgated Supreme Court Judges Appointment Ordinance 2025 is designed to enhance transparency by introducing merit-based appointments, asset disclosure requirements, and public vetting. The draft Supreme Court Secretariat Ordinance 2025 proposes to establish full administrative autonomy for the district judiciary, which is critical for its functional independence. As you know, this draft ordinance, draft Supreme Court Secretariat Ordinance, has already received the preliminary nod, approval of the Advisory Council. It's an exhilarating news that the original position of Article 116 of the Constitution has been restored recently by a read bench of the High Court Division. This hopefully will pave the way for complete separation of the district judiciary from the executive organ of the state. But nonetheless, the people are full of misgivings thereabout because of their past bitter experience in this regard. There goes an age-old adage, there's many a slip between the cup and the lip. Some hostile forces may be at work to undo your institutional independence. Let us hope for the best and prepare for the worst. Judges, needless to say, live through their judgments. So their judgments must be of very high standard and show proper appreciation of the laws and facts involved. In fact, their judgments speak about their quality as judges. A critical challenge now facing the justice system in Bangladesh is how to resolve the thousands of allegedly fabricated cases that continue to entangle the victims of enforced disappearance. Many of those caught in this web have already endured incommunicado detention, torture, and staged reappearances. Upon resurfacing, they have found themselves facing charges for the crimes they could not have committed, often because they were already in state custody at the relevant time. This apparently presents a grave miscarriage of justice and a direct violation of legal principles, most notably the requirement that guilt must be established for a specific act, not presumed on the basis of alleged association or ideology. It must be acknowledged that within this group, there may be individuals who do harbor radical beliefs, but the right to due process demands that those individuals be prosecuted only for the acts they have committed. It is also evident that large numbers of those currently being tried under the relevant laws have no professedly prima facie semblance of guilt, let alone the specific offences for which they stand accused. Many are caught up in political dragnets. This complex reality underscores the importance of careful and fair judicial scrutiny. However, the best guarantee of justice lies in the personality, efficiency, skills, impartiality, and boldness of the judges. A judge should treat every case, whether involving the Prime Minister or a man in the street, with equal vigor, rigor, and fervor. As the judges don their robes every morning, they should remember the words of the Constitution. The Republic shall be a democracy where all fundamental human rights and freedoms shall be guaranteed. This guarantee should begin with the judges. Let us build a judiciary where a street vendor in Dhaka or a garment worker in Khulna or a rickshaw driver in Sylhet can alike say, we trust the court, we trust the judiciary. The journey is strenuous, arduous, taxing, demanding, and exact, but the reward is immeasurable. Several landmark judgments of the Supreme Court of Bangladesh have fortified judicial independence, namely 8th Amendment case, Anwar Hussain versus Bangladesh, 41 DLR AD, 1989, page 165. Mazdar Hussain case, you know it very well. State versus Chief Editor Manav Javin, 57 DLR HCD 2005, page 359. Bangladesh versus Idrisur Rahman, 15 BLC AD 2010, page 49. Last but not the least, 60th Amendment case, as you know it very well. All these decisions have fortified the, independence of the judges of both the lower judiciary and the higher judiciary in categorical terms. In the 16th Amendment case, it was affirmed that the removal of judges must follow the constitutional process through the Supreme Judicial Council, and emphasized that judges should not be accountable to Parliament in the same manner as the President, Speaker, Prime Minister, or Cabinet members, as judges are not elected by the Parliament as in the United States. The Constitution of Bangladesh, as it stands now, does not authorize Parliament to impeach the Supreme Court judges, and nor does it grant Parliament any role in their appointment or removal. While the Constitution provides clear mechanisms for electing the President, other political executives, and members of Parliament, it distinctly stresses the independence, setting judges apart from other branches of the government. In a word, both the executive and the legislature are manned by elected people, whereas the judiciary is manned by unelected people. Late lamented Chief Justice of the then Dhaka High Court, Mr. Justice Syed Mahbub Murshid, was a very bold personality, both on the bench and off the bench. He was a multifaceted and multi-talented judicial statesman. He is a lighthouse to many judges of this country. According to him, no tyranny is worse than judicial arbitrariness, and no misfortune is worse than judicial subservience. Judges must be made of sterner stuff. They must have the guts to challenge the people in the corridors of power when any situation so demands. They must be bold enough to hold the government and the public entities accountable for human rights obligations. A timid, spineless, and remote control judge is not only a disgrace to the judiciary, but also a disgrace to the nation as a whole. There is no room for doubt that the bench and the bar are the two sides of the same coin. They go hand in hand. Both the judges and lawyers are imbued with the same jurisprudential ideas, albeit their roles are different. So any propensity of either side to carry its temporary ruffled feelings against the other to an unreasonable length destroys the moral foundations of both the institutions. This is why they should be on their guard to see that the moral foundations of both the institutions are not destroyed in any manner. The best judgment of the court, excuse me, the best judgment of the court is the product of the finest summations made by the bar. But unfortunately, there has been deterioration all around, affecting the quality of justice. The higher the quality of justice, this is very important, the higher the quality of justice, the more the confidence of the people in the court. The higher the quality of justice, the more the trust of the people in the court. In such view of the matter, the judges should strive hard to dispense quality justice. I mean quality judgments, to deliver quality judgments to the justice seekers. According to the observation of the Indian Supreme Court in S.P. Gupta's case, lawyers are equal partners. The lawyers are equal partners with the judges in the administration of justice. I am in full agreement with this view of the Indian Supreme Court. Anyway, it is manifestly clear that the role of the lawyers in the dispensation of justice is no less important than that of the judges. We have inherited the present judicial system from the British. This Anglo-Saxon judicial system faces significant challenges in Bangladesh. Number one, perceived corruption. This is one of the challenges that the judiciary of Bangladesh faces today. Number one, perceived corruption. I don't say corruption, I say perceived corruption. Even a hint of corruption or favoritism tarnishes the collective reputation of the judicature. Number two, case backlogs. Over 4.5 million pending cases delay justice, eroding public trust in the judiciary. Number three, political influence. Allegations of external pressure undermine judicial independence. Number four, accessibility. Rural citizens often view courts as distant, both geographically and culturally. These challenges are not insurmountable, but addressing them requires courage, creativity, and collaboration. To restore public trust, we must strengthen the following four pillars. Number one, integrity and impartiality. Justice must not only be done, but seen to be done. Lord Hewart. A judge should avoid even the appearance of bias. He should recuse himself from cases involving personal connections and uphold his ethical standards relentlessly. His integrity is his legacy. For the sake of emphasis, I repeat, a judge's integrity is his legacy. Number two, efficiency and innovation. Prioritize case management. This is very important. Prioritize case management, leverage technology for e-filing, virtual hearings, and digitized records, ultimately leading to introduction of e-judiciary. Advocate for more specialized courts to expedite dispensation of justice. Next, third point, transparency. Publish judgments promptly. Consider live streaming high-profile cases to dispel secrecy myths. Simplify legal language in decisions to enhance public understanding. Number four, accountability and engagement. Support judicial oversight mechanisms that respect independence while ensuring accountability. Engage with communities through legal literacy programs. A farmer in Rangpur should understand his right to fair trial. It is true that, as per Clause 4 of Article 94 of the Constitution of People's Republic of Bangladesh, the judges of the Supreme Court are institutionally independent. Again, according to Article 116, capital A of the Constitution, the judges of the district judiciary are independent in the discharge of their judicial functions. In this perspective, a million-dollar question arises. Are all the judges of the Supreme Court and the district judiciary mentally independent? I leave this question to you for your introspection and soul searching. To my mind, judicial independence of an individual judge is essentially his mental state, is essentially his mental condition. Unless the judges are mentally independent, they will not be able to dispense justice to the litigants in an impartial, neutral, and unbiased manner, being free from all sorts of extraneous influences. Theory without action is empty. This is very important. Theory without action is empty. The following strategies may be adopted by the judges. Number one, lead by example. Treat every case, whether involving a high up of the government or a pushcart driver, equally as per law. So you have to lead by example. Number two, reject complacency. Continuous learning is non-negotiable. Non-negotiable. Attend workshops on emerging laws and ethics. Number three, collaborate beyond the courtroom. Work with the Bangladesh Bar Council to reduce procedural delays. A TV segment explaining court processes can bridge gaps. Number three, champion technology. Push for AI-driven tools to predict case timelines and allocate resources. Use social media responsibly to share updates. Number four, humanize justice. Listen empathetically. A widow seeking land rights deserves patience as much as a corporate lawyer. Mentor young lawyers. So you should assume the role of a mentor. Mentor young lawyers. Their professionalism tomorrow reflects your guidance today. Judges are not merely arbiters of law. They are also custodians of hope as well. They are also custodians of hope. In their hands, in the hands of the judges, lies the power to heal societal fractures and inspire a nation. In order to uphold ethical standards, a judge has to recuse himself from conflicts of interest, treat all cases equally, regardless of the positions of the litigating parties in the society. In the words of Francis Bacon, judges ought to be more learned than witty, more reverent than plausible, more advised than confident. Above all things, integrity is their portion and proper virtue. It seems that Francis Bacon has summarized all the sterling virtues of a judge in the above mentioned observation. You see, our people crave for quick and inexpensive justice, but their craving has largely remained unfulfilled because of the complex, complicated, and cumbersome procedural laws and backlog of cases. Simplification of the procedural laws is the job of the legislature. By automation of judicial procedures and gradual introduction of e-judiciary, the backlog of cases can be reduced to a significant extent. While dealing with the backlog of cases, the roles of the court management and court administration come into play. By the way, it may be pointed out that a good judge is also a good manager of his court. A good judge is also a good administrator of his court. Justice-friendly atmosphere mainly hinges upon case management and court administration. As you know, the judiciary is the last resort of the people. The prevalent public trust deficit in the judiciary must be stemmed for the for the very survival of our polity. If the remedial measures as spelled out above are taken in right earnest, hopefully the image of the judiciary will be brightened and the people's trust in the judiciary will be restored to a great extent. Anyway, before I wrap up, I heartily thank the organizers of this event for inviting me and affording me an opportunity to say a few words here. Thank you very much. Thank you all. Now you are at liberty to ask me any questions. আপনারা প্রশ্ন করতে পারেন।
Thank you so much, sir, for your outstanding keynote presentation. We are really overwhelmed and pleased to have you in this program. We are highly grateful to you, sir. মানে সত্যি বলতে স্পেশালি দ্য জাজেস হু আর ইয়াং, যারা আপনাকে শুধু এতদিন নামে চিনতে পারতো বা আপনার জাজমেন্ট পড়ে আপনার নাম শুনেছে, তারা সত্যি অনেক বেশি প্রাণিত হবে বলে আমি বিশ্বাস করি। তো স্যারকে অনেক কৃতজ্ঞতা এবং ধন্যবাদ।